Welcome to our video on the California Privacy Rights Act, or CPRA. Today, we'll examine the scope and key provisions of this comprehensive privacy law that's reshaping how businesses handle personal data in California. The CPRA came into effect on January 1, 2023, amending and expanding the CCPA to strengthen digital privacy protections for California residents. The CPRA applies to for-profit organizations that collect personal information, operate in California, and meet one of the following conditions: have annual gross revenues in excess of $25 million in the preceding calendar year as of January 1st. Alone or in combination, annually buy or sell or share the personal information of 100,000 or more consumers or households. At least 50% of their annual revenue is generated from selling or sharing California residents' personal information. One of the key enhancements in the CPRA is the introduction of sensitive personal information, SPI, as a new category of personal information, PI, with stricter disclosure and usage limitations. Consumers can request businesses to limit the use of their SPI to that which is necessary to perform the services or provide the goods reasonably expected by an average consumer who requests such goods or services, or for the performance of specific enumerated business purposes. The CPRA requires a "do not sell or share my personal information" link for opting out of personal information sale and sharing, including SPI. Mandates a "limit the use of my sensitive personal information" link for controlling the use and disclosure of SPI. Recommends a single, clear link for customers to opt out of or limit the sale, sharing, use, or disclosure of their SPI. The CPRA enhances protection for California residents by granting them several rights. They can request corrections to inaccurate personal information that a business maintains about them, access information about automated decision-making processes, and request information on the logic involved, as well as the potential consequences for them, and may also request to opt out of the use of automated decision-making technology, which can include individual profiling. Request a business selling or sharing their personal information with third parties, refrain from further selling or sharing their personal information. Request to limit the use of sensitive data to only which is necessary to perform the services or provide the goods reasonably expected by an average consumer who requests such goods or services, or for the performance of specific enumerated business purposes such as prevent or detect security incidents. Request the deletion of personal information that a business has collected about them, with certain exceptions. Request to know the categories and specific pieces of personal information collected about them, the sources of that information, the purposes for collecting it, and the third parties with whom the information is shared. Opt out of PI sale or sharing, including for targeted advertising. Request that their personal information be provided to them in a portable and, to the extent technically feasible, readily usable format that allows the consumer to transmit this information to another entity without hindrance. Moreover, for consumers under 16 years old, businesses must obtain opt-in consent before selling or sharing their personal information. For those under 13, consent must be obtained from a parent or guardian. If a minor under 16 years declines, the business must wait 12 months or until the minor turns 16 to request consent again. Like CPPA, the CPRA requires the notice at collection to include the categories of personal information to be collected and the purposes for which the categories of personal information shall be used. Additionally, the CPRA requires covered businesses to disclose whether the individual's personal information is sold or shared, the retention period for each category of personal information, or the criteria used to determine this period. If sensitive personal information is collected, a disclosure identifying the categories of sensitive information, the purposes for its use, and whether it is sold or shared. Non-compliance with CPRA provisions can result in significant penalties for businesses. Businesses can be fined up to $2,500 per unintentional violation and $7,500 per intentional violation, or for violations involving minors' personal information. This occurs when organizations fail to fulfill consumers' rights in a timely fashion. Create and maintain up-to-date privacy policies or notices. Provide opt-out options when planning to share consumers' SPI. Assure non-discrimination when a consumer exercises their privacy rights. The California Privacy Protection Agency, CPPA, is tasked with enforcing the CPRA. It handles all legal and administrative matters and ensures businesses comply to protect the data and privacy rights of California residents. To learn more about global data privacy laws and how you can automate them, visit security.ai.